Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with another video on another topic from the security laws, and today's topic is the Securities Contract Regulation Act 1956. We are done with the SEBI Act and we are also done with the Depository Act, and now today we start with the Securities Contract Regulation Act 1956. I have been stressing on this point that this time security laws, they have been given 40% weightage, which is very important, which is very crucial. So please be very careful when you are preparing for your phase 2 examination. The security laws, they have a huge weightage this time. You have to be very attentive while you prepare for these security laws, alright? Before I begin, I would like to tell you that EduTap has come up with two courses for phase 2. The first is the test series and the other one is the live crash course. For your phase 2 examination, for the preparation of phase 2, it is going to be very helpful. If I talk about the features of test series, you get chapter wise test. So chapter wise test means you get tests, that means questions from each chapter. For example, from IPC, every chapter for IPC that is coming into your syllabus, and same goes for the company laws and same goes for the security laws. So you get questions from each of such chapters, right? So they have been divided, the questions, they have been divided according to the chapters. So it is going to be very helpful for your preparation. When you complete one chapter, you can refer to these questions and you can evaluate yourself, right? The second one is full length test. The full length test also includes the descriptive part. This time, as you already know, that descriptive part, it has been introduced by SEBI. So we are focusing on descriptive part as well. For your full length test, you get the evaluation. So the experts will be evaluating your test. So you will be getting feedback on your descriptive part also. And you also get one-on-one mentor support. And for the live crash course, all the features that I have mentioned for the test series, that is the chapter wise test, the full length test plus with evaluation and the one-on-one mentor support, they are all available in the live crash course. But there are two more things that you get. Those are, first, the live classes. You will be getting live classes. You will be getting live class on each and every subject that is part of your syllabus, right? And also you get short notes that will be helpful for you to prepare for the descriptive part this time. So if anyone of you wants to avail this offer, can refer to the link in the description below. So let's start with our lecture now. Question number 1. Which of the following is not a participant of stock market? Stock exchange, clearing members, demat account, depository or broker? So the answer to this question is option C, that is demat account. While we were doing the Depository Act, we have understood that what is a depository, what is a demat account. So I hope you remember that what is a demat account. Let's read the explanation. Dematerialized account is not a stock market participant. It is just a tool which helps trading in stock exchange, right? A demat account helps investor hold shares and securities in an electronic format. This we have done. It also helps to keep proper track of all the investments and individual makes in shares, exchange trade funds, bonds, mutual funds in one place. So demat account is nothing. It is just an account that helps the investors to hold securities in an electronic form. This we have done. I hope you remember this. So it is nothing. It is an account that helps investors hold shares and securities in an electronic format. So it is not a participant of stock market, but it is just a tool. All right. Question number 2. Which of the following are not true regarding the Securities Contract Regulation Act? It has total 32 sections. Under this act, most powers with the central government can also be exercised by SEBI. This act aims to prevent the undesirable transaction in securities. It came into force in 1959 or none of the above. So the answer is option D, as we know that it came into force in 1956 and not in 1959, right? So the Securities Contract Regulation Act, it came into force in the year 1956. It has total 32 sections. Under this act, most powers with the central government can be exercised by SEBI, and this act, it aims to prevent undesirable transaction in securities. Question number 3. Every participant of recognized stock exchange shall be accompanied by all the following documents, details except which one? So the answer to this question is E, that is none of the above, that is all of these documents, they have to be attached, right? Let's read this section. What does this section say? Section number 13, right? Section number 3. Okay. Any stock exchange which is desirous of being recognized for the purpose of this act may make an application in the prescribed manner to the central government. So the application, it is going to be made to who? It is going to be made to the central government. Every application under subsection 1 shall contain such particulars as may be prescribed and shall be accompanied by a copy of the bylaws of the stock exchange for the regulation and control of the contracts, and also a copy of the rules relating in general to the constitution of the stock exchange and in particular too. So such application, it is going to be accompanied by the bylaws of the stock exchange and such other rules that are relating to the constitution of stock exchange, right? And in particular, these are the things that have been mentioned. They are the governing body of such stock exchange, its constitution and powers of management, and the manner in which its business is to be transacted. So how the governing body of the stock exchange is going to be constituted, managed, and how it's going to transact, it's all has to be mentioned in such application. The powers and the duties of the office bearers of the stock exchange. So what are going to be the powers, what are going to be the functions of the office bearer of the stock exchange, that also has to be accompanied. The admission into the stock exchange of various classes of members, their qualification of membership, and the exclusion, suspension, expulsion, and readmission of the members thereof or thereinto. The procedure for the registration of the partnership as members of the stock exchange in cases where the rules provide for such membership. So wherever there is such provision, and the nomination and appointment of authorized representatives and clerks. So all of these, they have to be accompanied by such application that has to be filed to, it has to be filed to the central government under section 3 of this act. Alright. Question number 4. How many persons represent the central government on each of the stock exchange? So the answer to this question is C, that is maximum 3, right? It is not exceeding 3. Let's read it. So section number 4. The conditions which the central government may prescribe under clause A of subsection 1 for the grant of recognition to the stock exchange, it may include, among other matters, conditions relating to. So the qualification of the members of the stock exchange, the manner in which the contracts shall be entered into and enforced as between the members, and how a contract is to be enforced between its members, it also has to be accompanied. The representation of the central government on each of the stock exchange by such number of persons not exceeding 3 as the central government may nominate in this behalf. So it is not exceeding 3, that is maximum of 3 persons. So a representation of the central government on each of the stock exchange. So there is representation by the central government on each of the stock exchange by such number not exceeding 3 as the central government may nominate in this behalf. The maintenance of accounts of members and their audit by chartered accountants whenever such audit is required by the central government. Alright, question number 5. A recognized stock exchange may, with the prior approval of the Securities and Exchange Board of India, transfer the duties and functions of a clearing house to a clearing corporation for which of the following purposes: the delivery of securities, the periodical settlement of contracts and differences thereunder, payment of securities, A and C only, A, B and C. So the answer to this question is A, B and C, that is all of these, they are correct, right? So first we have to understand that what is a clearing house, right? So in a stock exchange, there is always a buyer and a seller, where one person is buying certain number of shares, there is another person who is selling these shares, and when a trade between them is settled, the buyer, he gets these securities and the seller, he gets its worth in the form of money. To complete this transaction, the clearing house, it acts as a facilitator. It completes the process of delivering and receiving the shares or the funds to the buyer and seller. So it acts as a facilitator between the buyer and the seller. So now let's read it. This is section number 8A, right? A recognized stock exchange may, with the prior approval of the Securities and Exchange Board of India. So the prior approval has to be taken of the SEBI. Transfer the duties and functions of a clearing house to a clearing corporation, being company incorporated under the Companies Act 1956. ठीक है, incorporated under Companies Act 1956. for the purpose of, and what is the object behind this, what is the purpose, the periodical settlement of contracts and the differences there under. So the periodical settlement of contracts, and if there are any differences for that purpose, the delivery of and payment for securities. So this we have understood, it is for the delivery and the payment of securities and any other matter incidental or connected with such transfer. Alright, question number 6. Who appoints members of the clearing house to carry out its operations? Is it the stock exchange? Is it the cleaning corporation? Is it NSDL or SEBI or the central government? So the answer to this question is clearing corporation itself, right? Clearing corporation appoints various members on its behalf, which helps it carry out its operations. Question number 7. Where the governing body of a stock exchange objects to any bylaws made or amended by the Securities and Exchange Board of India on its own motion, within what period of the publication thereof in the Gazette of India apply to the SEBI for revision thereof. So the answer to this question, it is B, that is within 6 months, right? Let's read this section also. This is section 10 clause 3. Notwithstanding anything contained in this section, where the governing body of a recognized stock exchange, it objects to any bylaws made or amended under this section by the Securities and Exchange Board of India on its own motion, it may within 2 months for the publication thereof in the Gazette of India under subsection 2 apply to the SEBI for revision thereof. So they can do it within 2 months, right? They can apply for the revision within 2 months, and the Securities and Exchange Board of India may, after giving an opportunity to the governing body of stock exchange to be heard in the matter. So they have to be given an opportunity to be heard, revise the bylaws. After giving them that opportunity, they can revise the bylaws so made or amended. Anywhere any bylaws so made or amended are revised as a result of any action taken under this subsection, the bylaws so revised shall be published and shall become effective as provided in subsection 2. So then that revised bylaws, they are going to be published and then they are going to be effective. I hope this also is clear to you. Moving on, question number 8. For any reason or in situation of emergency, central government can ask the stock exchange to suspend its business for a period of not more than, so it is B, that is 7 days. So it is for the maximum of 7 days that they can be asked to suspend their business, right? 7 days. Section number 12 deals with the powers to suspend business of the recognized stock exchange. If in the opinion of the central government, so who has this authority? It is the central government. If in the opinion of the central government an emergency has arisen and the purpose of meeting of emergency, the central government considers it's expedient so to do, it may by notification in the official gazette for the reasons to be set out there, direct a recognized stock exchange to suspend such of its business for such period not exceeding 7 days. So what does that mean? That the central government, if it thinks fit, if it is of the opinion that there is an emergency and because of that emergency a stock exchange has to be suspended, it can do so but not more than 7 days, and it can do so by a notification in the official gazette, and there the central government, it has to mention the reasons, right? Direct a recognized stock exchange to suspend such of its business means that they can ask to suspend such business. Such of its business, it means that they can ask to suspend any of such business, right? For period not exceeding 7 days and subject to such conditions as may be specified in the notification. And if in the opinion of the central government the interest of the trade or the public interest requires that the period should be extended, may by notification extend the said period from time to time. So this 7 days period, this can be extended from time to time, but in the same manner, but it has to be by a notification, right? But there is also a proviso. Proviso reads as provided that where the period of suspension is to be extended beyond the first period, right? Where it has to be extended beyond the first period, note notification extending a period of suspension shall be issued unless the governing body of the recognized stock exchange has been given an opportunity of of being heard in the matter. So if they want to extend the first period of 7 days, right, the first set period of 7 days, then in that case they have to again give an opportunity to the governing body to be heard. Then in that case they have to again give an opportunity of being heard to the governing body, right? So this is provided that where the period of suspension is to be extended beyond the first period, no notification extended the period of suspension shall be issued unless the governing body of the recognized stock exchange has been given an opportunity of being heard in the matter. Question number 9. Every recognized stock exchange and every member thereof shall maintain and preserve for such period not exceeding -years such books of accounts and other documents as the central government, after consultation with the stock exchange concerned, may prescribe in the interest of the trade or in the public interest. So the answer to this is E, that is not exceeding 5 years. They have to maintain such books of accounts for 5 years, right? Not exceeding 5 years. Let's read this. This is section number 6. Powers of the central government to call for periodical returns or direct inquiries to be made. So every recognized stock exchange shall furnish to the SEBI such periodical returns relating to its affairs as may be prescribed. Every recognized stock exchange and every member thereof shall maintain, that is, it is mandatory, they have to maintain and preserve for such period which is not exceeding 5 years such books of accounts and other documents as the central government, after the consultation with the stock exchange concerned, may prescribe in the interest of trade or in the interest of public. And such books of accounts and other documents shall be subject to inspection. They can be inspected at all reasonable times, and who is going to make such inspection? It is going to be the SEBI, right? So I hope this is also clear to you. This is not exceeding 5 years. They have to maintain such book of account. They have to maintain such books of account for how many years? Not exceeding 5 years. All right, question number 10. The Securities Contract Act 1956 aims at which of the following? So what is the purpose behind this act? So the answer is all of the above, that is giving the central government the power to regulate stock exchange and clearing corporation through a process of recognition and continued supervision. So it gives the powers to the central government to regulate and control the clearing houses and the stock exchanges. Regulating listing and delisting of the securities on stock exchange, regulating contracts in securities, preventing undesirable transaction in securities. So all of these statements, they are correct. That is, this act, it aims to prevent the undesirable transaction in securities. It gives the central government the regulatory jurisdiction over, we have read this, it is Stock Exchange and Clearing Corporation through a process of recognition and continued supervision, contracts and securities, listing and delisting of the security on stock exchanges, right? Question number 11. If a person owns and keeps a place other than that of a recognized stock exchange which is used for the purpose of entering into or performing any contract, what could be the penalty imposed to him? So the answer is B, that is C or D or with both. That is fine which may extend to 25 crore rupees and imprisonment for a term which may extend to 10 years. Let's read this section. This is section number 23. So any person who owns or keeps a place other than that of a recognized stock exchange which is used for the purpose of entering into or performing any contracts in contravention of any of the provisions of this act. So if he is keeping any such place that he is using for the purpose of entering into any contract which is in contravention with this act and knowingly permits such place to be used for such purpose, and he is knowingly permitting to be used such place for such purpose, or shall without prejudice to any award of penalty by adjudicating officer or the Securities and Exchange Board of India under this act on contravention, be punished with imprisonment for a term which may extend to 10 years or with fine which may extend to 25 crore rupees or both. So the imprisonment, it can extend to 10 years and the fine, it can extend to 25 crore rupees. Question number 12. If one deals in securities designated as illegal or prohibited securities under the Securities Contract Regulation Act 1956, then such person is punishable with. The answer is C, imprisonment for a term which may extend to 10 years, or with fine which may extend to 25 crore rupees, or both. Let's read this also. So if one deals in securities that has been designated as illegal or prohibited securities under this act, then such person, he is punished with an imprisonment which may extend to 10 years or with fine which may extend to 25 crore rupees, or he can be liable for both of these as well. Question number 13. Which of the following section of the Securities Contract Regulation Act 1956 is related to the powers of stock exchange to make bylaws? So the answer to this question is option B, that is section number 9. So section 9 of the Securities Contract Regulation Act 1956, it provides for the power of the stock exchange to make bylaws. Question number 14. Contracts in derivatives shall be legal and valid if such contracts are traded on a recognized stock exchange, settled on clearing house of recognized stock exchange, parties and terms must be as the central government may specify. So the answer to this question is, that is E, that is all of these, they are correct, right? It is section 18A of the act. Notwithstanding anything contained in any other law for the time being in force, contracts in derivatives shall be legal and valid if such contracts are traded on a recognized stock exchange. So if they are traded on a recognized stock exchange, they are legal and valid. Settled on the clearing house of the recognized stock exchange, or in accordance with the rules and bylaws of such stock exchange, between such parties and on such terms as the central government may by notification in the official gazette specify. Question number 15. Section 23JC of the Securities Contract Regulation Act 1956 deals with. The answer is option D, that is continuance of proceedings. Let's read this section also. Where a person dies, his legal representative shall be liable to pay any sum which the deceased would have liable to pay if he had not died, in the like manner and to the same extent as the deceased. So his legal representatives, in case a person has died, his legal representatives, they will be liable to pay in the same manner as if that person has not died, like in the same manner and to the same extent, provided that in case any penalty payable under this section, a legal representative shall be liable only in case the penalty has been imposed before the death of the deceased person. But that penalty, it has to be imposed before the death of the deceased person, right? So the legal representative shall only be liable if that penalty was imposed on the deceased person before his death, right? So this was section 23JC. Alright, question for achievers now. Which of the following are correct with regard to the clearing corporation as per the provisions of the Securities Contract Regulation Act 1956? A recognized stock exchange may transfer the duties and functions of a clearing house to a clearing corporation. Prior approval of SEBI is not required to transfer the duties and functions of clearing house to clearing corporation. Clearing corporation has to make bylaws and submit it to the stock exchange for approval. All are correct or none of them are correct. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTab. Thank you.